315. What is the predicament, my lord? The person is facing the order of removal for the charges which were never incorporated into the charge sheet, my lord. Twice he appeared before the Honorable Learned Cat below, my lord, and the review has already been. He's in such a deplorable condition, my lord. I'm beseeching your lordship to just a consideration any day your lordship's convenience after coming from the circuit, etc. My lord.
We are not according priority to any matter in hearing. Sorry. Yes.
Hearing matter, your lordship. Printing since 2017, your lordship.
Sorry.
My lord, on 24th March, lordship was pleased to pass an order, my lord. Till date, my lord, the order has not been uploaded, my lord.
24th March.
March, my lord.
We'll see. What is the number? Give the
Well,
case.
Lordship listed.
Yes. I think I have completed. Okay.
Number 1.
Item number 1, I beg to appear for the petitioner, my lord. My lord, this matter was disposed of by your lordships. My lord, I do not know why it is appearing in the day's list, my lord.
Yes, sir. It should be Bunia. It is for correction of the cause title. In the writ petition, the name of the petitioner is Basavi Pramanik Bhunia.
Yes, ma'am.
But in the order, it has been typed as Basavi Pramanik. So that has to be
My lord.
correct. Yes. A report has been submitted by the
I'm grateful, man.
Deeply obliged, your lordship.
Item number 7.
I'm for the appellant in this matter.
for the respondent.
But your lordship will kindly, I'm for the appellant husband. I'm challenging, my lord, a judgment by which, my lord, the suit filed for divorce has been, my lord, diffused on the ground that there was a previous suit which stood, my lord, dismissed for default. Now, my lord, that is the only ground. Now, my lord, your lordship will kindly come to page 72 for the judgment.
Twenty-nine, 523.
Lordship.
Yes.
But the only point, my lord, the learned judge was of the opinion that since there was a previous suit which stood dismissed for default and it was not restored, therefore, my lord, the second suit is barred. So this is the only point because the court did not go into, my lord, the merits of my, my lord, the plaint case, not decided on, my lord, any of, my lord, the allegations that I had made in the plaint.
Respondent has appeared.
Respondent had appeared. And she also adduced evidence.
No, here also she has appeared.
Here my learned friend is appeared. Special marriage at work for. Now, my lord, the court has, my lord, come to a conclusion at page 78 that, my lord, Order 9, Rule 9 principle applies. Now, my lord, the point that I'll be raising before your lordship, whether, my lord, the provisions of the CPC in toto applies, my lord, in a proceeding, my lord, under the Special Marriage Act or not. Because the Special Marriage Act itself says, my lord, that the court has to be satisfied about certain parameters before grant of, my lord, a divorce. Now, my lord, only ground that has been applied here is, my lord, the dismissal of, my lord, my previous suit. And previous suit was also dismissed for default. So there was no, my lord, decision on merit on my application about why I am praying for a divorce.
No, the question is of procedure and maintainability, not as a ground for divorce.
Lordship.
There
That is not because my previous suit also dismissed for default. Well, your lordship may very well say that why my client did not attempt to revive that suit. So that might be a very valid question. But apart from
Therefore,
that,
we are observing prima facie based on what we are looking at and what you are submitting. There is no denying the fact that the parameters for divorce are very well contained in the Special Marriage Act.
lordship,
The point is of procedure.
lordship.
It's not a question of whether there is a valid ground for divorce or not. The
But
point-
that I will, either, my lord, I accept or, my lord, I fail on the basis of my pleadings. I have to prove, my lord, whatever I have stated in my plaint about, my lord, the matrimonial offences to succeed. But for that, my lord, the evidence has to be, my lord, led before the court on merits.
No, but that is on the merits.
Lord.
We are on the procedure and maintainability,
Lordship.
whether the procedural aspect allows you to file afresh or not. Supposing it was dismissed on merits, then also you could have filed afresh.
But
Could
here-
you?
But here, my lord, there is no bar under Order 9, Rule 9 according to
So
my
therefore,
submission.
that is the question to be seen,
Lord.
whether the conditions exist under the Special Marriage Act, that will
Lord.
come later.
Lord.
The primary thing is whether it could have been done in this way or it was required to
Lord.
be mandatorily resorted to for
Lord.
setting aside of the decree ex parte or whatever it was.
That dismissal. That was
Dismissal and default.
earlier dismissal.
Yes.
Now, my lord, other point is, my lord, this is my argument rather. Now, my lord, in a matrimonial proceeding, my lord, if a particular suit, my lord, is dismissed either for default or my lord, on certain other, my lord, grounds that I could not prove, my lord, my allegation contained in the petition. But I am not precluded from bringing, my lord, another suit on the other grounds, my lord, where, my lord, the matrimonial offences I allege. Suppose, my lord, I file a suit alleging, my lord, an X allegation. I could not prove it. Now, my lord, the principles of Order 2, Rule 2 will not apply in a matrimonial proceeding. I can bring another suit, my lord, to urge about, my lord, the facts concerning Y, and my lord, also have it tried by the court. Because all that, my lord, the learned judge should have, by reference to, my lord, the Special Marriage Act under which, my lord, the application was made, is to
I'll not take much time, my lord.
No, that
All right with you all.
Yes, yes. But my adjournment record has some day after tomorrow.
very well. But I am not standing in the way.
All right.
Subject to convenience of the court.
We are here every day. Instead of adjourn not today, say adjourn.
Item number 9.
The item I am praying for 1 week's accommodation, Your Lordship. My Lord, I am led by Mr. Sankarat Mukherjee. He is on leg on others court, my Lord. Other.
Item number 10.
My lord, 10, I am for the appellant petitioner, my lord. The defect leave may be granted to the remove the defect. I don't know what is that. Well, 1-2 days, there is no.
मैं 8 सप्ताह का हुआ था go out of the CHA.
Item number 11.
My lord, I am appealing for the petition, my lord. In this matter, my lord, similar matter, your lordship passed the order on 3rd April, my lord.
My lord, the similar issue is pending before the Honorable
Apex
Supreme
Court.
Court, my lord. If your Lordship kindly
Tag with the earlier matter, my lord. My lord, WPCT 120 up to 2024. Second service Spencer, my lord.
Where is the matter pending consideration?
My lord.
In which case, where is, give the SLP number?
WPCT 120 up to 2024. Union of India, Mount Mercy. Last order passed on 3rd April. Order was not uploaded, my lord, in the website 3rd April.
No, we are asking you to give us the SLP number.
That's SLP number. I'm giving, my lord. This is
Give that.
my lord, 27725.
We are informed
copy,
by the parties.
Item number 12.
I am for the petition applicant.
Lordship,
So
on
this is
behalf
a video
of
service.
respondent, I'm praying for not today, your lordship.
Huh? Oh, Lordship. We already served the copy to all the respondents.
Many respondents are there.
6.
You are representing all.
Lordship, Mr. Chirodip Sinha is appearing, he's out of station. I don't know.
For all the respondents.
Lordship, I don't know that.
Then why are you here? Then you should not be here if you don't know anything. Yes, let us.
Lordship, the tribunal has given the has admission has passed the order at the admission stage. Your Lordship.
Yes.
Page numbers running page 64 and input order is running page 5 last page. In view of the above OA stands disposed of at admission stage, Your Lordship. Not giving a chance to us to say anything about it. Really is the big concern, Lordship, and there are a lot of varieties of the service matter. रिटायर करके लिए इसमें Lordship, please come to my application number 6. Page number 6, Your Lordship. There are the 6 persons. One is retired in the 2013. After that, someone is 15, 13, 22, 21, 21. 6 different persons has retired on different dates. They have clubbed in the one application. Lordship, this is one most beyond the law. Number 1. Number 2, are they eligible to file this application or not? There is 2 things. One is the CLI, Chief Loco Inspector, and one is the running staff who is running the train. There are 2 things. If you are running the train, then you will get the 55% pension benefits. If you are the CLI, Chief Locomotive Inspector, you will get only 30% because you are the supervisor. Supervisor cannot be the running staff. Lordship, who is running the train, and there is a criteria who are the running staff.
Where the tribunal has said that these petitioners are running staff.
Lordship, when I will get a chance,
where the tribunal has held that they are running staff, that you are making
not
this
just
submission.
hearing on the disposal.
Where the tribunal has held that they are running a staff, that you are making all this submission. Where it has held, show us, where is the finding that they are to be treated as running staff?
If they are not running staff, they are not eligible to get?
You said that only running staff can get 55.
Lots.
They are inspectors, they are supervisors, they are not running staff. They are supervisors, they are not running staff, they can get 30%.
Lots.
So therefore, you have filed this writ petition. Now, where the tribunal has held that they are to be treated as running staff and given 55%, show us this finding.
No, Lordship, they have only just one judgment of the previous, they have sent.
Where the tribunal has held such thing that you are aggrieved, show us. Where has the tribunal held that they are to be treated as at par with running staff? Where is the finding which offends you?
I'm coming. No? Lordship, page number 3.
Yes,
paragraph
read
no-
the finding.
Learned counsel for the applicant submitted.
Submission is not a finding, sir. We are asking you, where is the finding? You are making a very emphatic submission that they are supervisors, they are inspectors, they cannot claim the benefit being granted to running loco pilots. Where is this finding?
Sir, I did not get a chance to say before the tribunal.
Where is this finding without giving you a chance?
Findings, I'm not.
Then why are you here? Please read para 7, what the tribunal has said.
It is settled portion that benefit granted to a state of the employees of judicial orders would be extended to all other similar.
If found eligible,
Lordship.
then you will file a writ petition. Very unfortunate. Yes, Learned counsel for the.
Substitution. But your lordship, on the same point, I have been given by Mr. Sinha. Same point, your lordship, you should pass this order.
No, here there is no decision. Here it has been left to them to decide. You have not challenged the order. Then you have to go and convince them. What can be done?
Lordship is not modifying the order of the.
Nothing, nothing. Yes. Give your appearance. Give your appearance.
But in this matter, I appear for the Petitioner Union of India.
Yes.
The respondent has been served. I have got the receipt of track record, but affidavit of service could not be affirmed. If your lordship directs, I can affirm it in course of this day and file it.
Let's see what is the issue.
Issue is this: a certain amount was recovered from the respondent's pensionary benefits, about 7 lakhs and odd.
On what ground?
Overpayment, due to overpayment. Now, tribunal was
on fixation of the last pay drawn. What is the
continuous overpayment?
On what ground?
Wrong
last pay drawn was wrongly fixed.
Wrong fixation.
Or there is an earlier salary which is at some point of time some enhancement was granted. What is the issue?
Let me see the judgment. Now, the tribunal.
Anyway, so he retired and you started making the recoveries.
No, we started one lump sum recovery was made, 7 lakh and odd from his retirement dues. Thereafter, tribunal.
Post? He retired from which post?
Peon. Now, tribunal was moved. Yes. Tribunal directed us to pay the recovered amount. Accordingly, we have done.
All right. That you have refunded?
Yes, we have refunded. Now, my lord, second way was moved by the respondent, my lord, claiming interest. My lord, in the first way, tribunal did not say. Tribunal did not say that you pay interest on the recovered amount. Simply said that you refund the amount which you have recovered. Accordingly, we have refunded. Now, my lord, in the second way, the tribunal, my lord, granted 7% interest.
Where is the order
That is-
passed? Is the order passed in the earlier litigation? It is there in the earlier way,
Just a minute.
where there was a direction to refund. Oh, yes, it is there. It is quoted at page 5 of the CATS order.
Yes.
Paragraph 9.
Yes.
Accordingly, the impugned orders are quashed. The respondents are directed to refund the entire recovered amount forthwith,
Yes.
with liberty to act in accordance with law and recover accordingly. So that liberty was given to you.
The respondents are directed to refund the entire recovered amount forthwith,
With
with
liberty
liberty to act in accordance with law and recover accordingly.
So that liberty
So
was given.
that liberty was given to us. Now, my lord, the
Just a minute. We have understood. Let us read after. How long it was recovered? When was it recovered?
let me see. My lord. Now, kindly see paragraph 3 of the judgment, earlier judgment at page 31. Paragraph 3, page 31. (1009) days of EOL, not refixation. I stand corrected, my lord.
So about 3 years she has been deprived. And this was this was recovered from which amount? Provident fund.
PCRG, death cum retirement gratuity.
Then
that has been refunded. No, that is
grade 4 employee.
But
3 years.
which is subject to your lordship's kind consideration. Well, this is absolutely hid by constructive res judicata. In the earlier way, the tribunal never directed us to pay the recovered amount along with interest. So, in the second way, the respondent came up before the tribunal claiming for interest. Tribunal granted the relief. We are aggrieved by that.
Where is the provision under which this gratuity is paid? What is the statutory provision? Let us see. There is CCS gratuity rules.
Yes.
Where is that? Does it contemplate grant of any statutory interest? If it does, then even if the court has not said If it doesn't, then maybe we don't know, you may have a case. Where is the provision? Let us see.
Well, let me check up and come back. Let me check.
Come with it. Come with it.
But
Senior counsel submits. It is submitted that in the meantime, the
Item number 14.
14, my lord, I'm praying for not today on behalf of Sharda Shah, my lord.
not.
Item number 15.
Lordship, Lordship, Mrs. Chandrayalam is appearing on behalf of the petitioner. She is not well, praying for not this week.
On grounds of the
Item number 16.
For the applicant, applicant, I have served to the, it's a very limited question of fact involved,
somebody is appearing for the respondent.
No, this is the first day the motion is appearing, but I have served to all the respondents, This is my affidavit of service, I constrain to file this application before the learned tribunal for the prayer, which is at 44. Why I constrain to file, because my candidature for the RRC examination was rejected on the ground of alleged mismatch of handwriting. That particular information supplied to me by way of the RTI reply, and then after I challenged that particular order of the RRC before the learned tribunal by saying that let this particular handwriting be examined from the Central Forensic Science Laboratory. Because there's a lot of cases, which has happened before the tribunal, where it was alleged by the GDSQ examiner that there's a mismatch, but subsequently after filing of the Central Forensic Report, it appears there's no difference in the handwriting. By assuming, I filed this application, let the particular entire record be examined by the Central Forensic Laboratory, On that day, when the motion was taken up before the learned tribunal, I was before the Honorable Apex Court, and my learned junior sought time for the accommodation. But on that particular day, there were several other RRC applications was pending. So, the learned trial judge before the learned tribunal, without going into the merit of the application per se, has disposed this application by granting the opportunity to represent, and then after representation we considered. That is that the order impugned, passed in the OA is Next at page 92, you'll also.
Where is the order passed in the OA?
That is its page, my lord.
92, paragraph 4, your lord. And the relevant portion is that paragraph 4 at 93.
Then after I challenge this order by way of review application, that was also disposed of, dismissed, my lord.
Where is your prayer in the OA?
Yes. That prayer.
Not this, not the review, OA.
Yes. Kindly come to page 44, you'll also. That is at serial number 8, relief sought for.
And your review?
That is after page 124, my lord. Here the prayer is cast. It's placed in verbatim, my lord, and despite that, it has not been considered by it.
No, where is your review application?
Okay, review application, my lord. Application, my lord. Review application attachment. Yes, well, it starts from page 95, will also. And I've stated the predicament on my part on that day, my lord, at para 3 onwards, my lord. Page 99.
Yes, you are appearing. Just see.
Application, my lord, your lordship kindly the order by the review application.
Yes, we have seen that. But that is the only option left to him. His prayer is at variance with what has been recorded in the tribunal, as if he is only seeking consideration by the railway authorities. His prayer is that it has to be considered by the forensic science laboratory. Whether it is to be allowed or not, we are not on that.
Identical matter, your lordship, my lord, the similarly situated person who
That the tribunal has proceeded on that case.
There was application, my lord, your lord kindly sees.
No, you come to the relief at page 44. Yes, relief B. And the tribunal has proceeded that yes, all are to be granted the same relief. Now it is open for one petitioner to take a different ground. Why can't take? There is no requirement that they all have to maintain uniformity. And if the tribunal, maybe there were a lot of matters listed on that day, with all those matters, this has also been disposed. Whether it is to be granted or not, that's a different thing. But
Directed to make an comprehensive representation before the authority concerned, as usual, my lord, in the other cases also.
no, but the tribunal has not done anything.
Even my lord, if it is the wrong, my lord, the review application, my lord, in the
No, it's not wrong. See, it is an error. It is an error of record. There is no such prayer that the authority should consider. There is no such prayer. The prayer is for the CFSL to consider. Where is the prayer that authority should consider? There is no such prayer.
And that prayer is stated in the review application by the learned tribunal, madam. They have taken that consideration. Then after
That's
they have gone
because
into
in your review in the first paragraph you have quoted the prayers. Therefore, the tribunal this time has taken note of. In your review at the very outset, you have quoted the prayer in the first paragraph. So the OA order you have challenged or you have not challenged? Order passed in OA. Have you challenged that?
Yes, yes. That is in my prayer, madam. What I have stated to pause and set aside the order dated 5/9/2023 and order dated 6/3/2024 passed in OA number 1077 of 2023 and RA number 03 of 2024. Both, madam.
Tribunal should have considered his prayer. We don't know whether it's to be granted or not. That's a different thing. Yes, there are judgments. There are judgments to this effect that it is required to be pointed out to the same court. Show us one judgment.
Well, I'm not, because madam, this is apparent from the fact ballot, so I'm not prepared on a point of judgment, madam.
That you show us.
Because there's the issue settled ballot, because the point which I have taken, the substantive prayer which I have made before the tribunal ballot, and the matter which was listed with regard to the creation of the waiting list, I am asking for the different.
Where is the judgment, sir? Show us the judgment.
But I'll take, if your lordship is giving direction to provide the judgment mallet, I'm seeking adjournment mallet, I'll provide that within 2 days. But I presume mallet, because this matter is settled on law mallet, and therefore I did not do.
Therefore, we are asking you. We know there are judgments. We cannot recall.
I'm not prepared, mallet. For the judgment part is concerned, mallet. I'll look into those judgments. I'll do
Court
my
has said in many judgments that if such a situation occurs, the best course is to tell the court where this has happened. That look, this is my prayer was this way, and it has been recorded like this.
I will do my research.
That course you have adopted. We just want to take note of that.
Yes, I'll do. I'll provide the judge. Subject to lordship.
When? Tomorrow, day after, when?
Day after tomorrow, mallet.
As paid by Learned Counsel for
Was 17.
On this matter, my lord, I appear for the respondent, my lord.
I am for that.
My lord, this matter, my lord.
ব্রিফটা দিন
বলেন না, আগে বলে নি, একটু বলে নি দুলাইন, তারপর করে বলে আপনি বলে দিচ্ছি। Well, I appear for the respondent in this matter, my lord. My lord, your lordship may recall that the order passed by your lordship dismissing the appeal on the similar point regarding the point of the giving the effect of the fifth pay commission for the GST inspectors. All the appeals already dismissed, or same appeal has been
You
again
think
filed.
we have that good a memory? That we
Yes,
will
my lord. Your lordship has
remember.
My lord, your lordship has passed at least 3 judgments I am having with me.
Maybe you are
kindly-
not saying you are wrong, but you say we will remember.
No, your lordship may recall.
I don't have that much sharp memory.
I have, my lord, understood that what is
May I
the
please
basics of the judgments your lordship was citing, my lord. We are learning from that. That is why I was little bit, my lord, enthusiastic in making this submission.
What is the issue? Let
Nothing
him.
remains, my lord. You will also.
My lord will see page 225, that is the circular. But this was
No, the issue is saying he's saying we have decided the
issue is my lord has not decided this issue. The issue was decided by a coordinate bench with regard to income tax department. Now, subsequently, there was a judgment by the Telangana High Court, and thereafter, based on the Telangana High Court, the impugned orders have been passed, my lord. Telangana High Court and the Calcutta High Court, where the income tax department, here CBIC is the department where the CGST and customs.
not CBDT.
Not CBDT. Now, in that case,
So
also,
what
my-
difference does it make? There is
My
a
lord, it's-
different circular.
This, my lord, will kindly see the circular, which is at page 225.
No, we are asking you whether there is any
It's a
distinction.
different circular. It is a different circular.
There is a
This-
difference.
This circular is different. My lord will kindly see, which is at page 225.
In all these cases, they are arising out of CBDT.
My lord, the circular is with regard to CBDT and CBEC,
In-
both.
Then,
Both are there. my lord.
Then-
I'm not challenging that.
then
What has happened thereafter is an anomaly committee was set up for the purpose of CBDT, pursuant to the order judgment that was passed by the Calcutta High Court. Now, similarly, in the Telangana High Court, a similar order was passed, my lord. Now, consequent to that, the anomaly committee has not been set up. Now, today, I have not been able to. Today, it has a persuasive value to my lord. Here, the CBDT judgment has been passed from Calcutta High Court, which has been followed by the Telangana High Court with regard to CBEC.
My lord, basic, my lord, may I submit one?
no, we are first, we are not, we will not stop you from making submissions. But when we make a query, we expect that you will please respond.
Right.
In all these three cases that he has handed to us,
Same.
none are arising out of CBIC.
That I don't know.
So have a look first. That is what we are saying. Let us see. We don't know. Let them.
Let them justify what they are saying.
Yes, my lord, same.
Then
Then
how
nothing
can we
remains.
take a view contrary?
That is my submission.
My lord.
Then we cannot take a contrary. Which judgment?
My lord, the first one is, my lord. The second one also on the same line, and third one.
CBIC, all CBIC.
My lord, on the basic point that fifth.
And I believe that there was some consent also recorded.
No, not consent. What was recorded was that this order was placed before my lord.
দিয়ে দিচ্ছি, দাঁড়ান, এখন জোর করে দিলে হবে না, না তো অন্য ম্যাটারে আছে। এখন
In
তো-
fact, my lord,
In fact, there it was the Union of India which was saying it is all.
my submission only was that this judgment, the Telangana judgment went before the Supreme Court and Supreme Court had dismissed that. Which is why that, but my lord will kindly not.
You had appeared in these cases also.
Yes.
Then same orders.
Same order.
That's why I said these are the same orders.
Same order.
But my lord will kindly see that it should not go in as a consent, my lord. My lord, there was a difficulty which my learned friend faced from the department because of that, for her fair submissions.
My lord, up to this, my learned friend stated very nicely, my lord, is same point. I also, only one point.
The stand of the Union of India is recorded in all these three orders.
My lord passes similar order.
Same order has to be passed.
And my lord,
But my lord will kindly record my objection. That is the
one humble submission. If it is recorded, then I will, my lord, with a very humbly, I will pray that with the same
Then you make
grievances,
your
how
objection.
many times
You
a
consider
citizen can
whether it is
today. It's not question of objection. My objections are there in the grounds, my lord. But today,
Sir,
say
we are
that these
not
orders have
we are not here to pass orders just because you feel that. There is the same issue.
Yes.
3 times you have come, you have represented, you said that look, it is decided. And here you will object.
No, I am
That
not
option is
objecting.
available.
My lord, I am not objecting.
Then
I have
what
come-
objection
I
will
have
record?
come with a writ petition.
Then what objection
against
will record?
An impugned order.
Yes.
My lord has passed orders on
On your submission.
in similar conditions.
On your submission.
No, not on my submission.
Have a look.
Yes, my lord.
Have a look.
Yes, my lord. On
Have a look.
on the order that has been passed
Yes.
by the Telangana High Court,
Yes.
which went before the Supreme Court, and Supreme
Yes.
Court had dismissed that. So this is the
See
submission
paragraph. See paragraph
Yes, I have
2.
seen that, my lord.
We have recorded that it is a fair stand you have taken because the issue is decided and therefore we have done
My
this.
lord passes the same.
Therefore, how can they can't
My
be a
lord.
different today?
My lord, one thing, my lord, I submit, my lord, in connection with it. Similar observation was made in one of the judgment of the Supreme Court that each and every time the department was preparing appeal, ultimately a cost was imposed. My learned friend knows that. Because same grievances, we are facing trouble with the same grievances. Nothing remains in this appeal. I am not asking for any. Yes, that is
My
my.
lord, then 17, 41 and 42 today are similar matters. Item number 41 and 42 also are similar matters.
মেনটেনেবল না উনিও তো বলেছেন ওনাকে আর কতবার বল উনি তো একই কথা বলছেন নতুন কিছু হ্যাঁ আমি ভালো বলেছেন আপনি আমিও আমার থেকে আপনি ভালো বুঝবেন এই সাবজেক্টটা করেছেন আপনি কি পেয়ে যাবে পেয়ে যাবে তাহলে আর 3 দিন চলবে
ইমপিউন্ড অর্ডার নিকাল তো
তাহলে মামলা হবে না তাহলে চচ্চড়ি হয়ে যাবে
হ্যাঁ
কিছু বললে চচ্চড়ি ওটা এখানে ডিসাইড করার মতো যেটা সেদিকে হচ্ছে অন্য মামলায় হবে না
all three.
Seventeen and
41 and
please give appearance in all the 3 matters.
Grateful, your lordship. না কথা করে
I was actually not saying against it. What I was trying to
No, we understood what you are saying. We have appreciated what you are trying to say. We have understood, but therefore we said we have recorded that it's a fair submission.
exactly that is what I have explained to her also. But you know, my lord, sometimes juniors can be made scapegoats.
No.
Profession and
That
we stand for them.
yes,
we fight for them. But somehow they become scapegoats at some stage or the other. Sad but true.
not in this matter
No. It's not nothing relating to you. My lord is
I am
understanding
also-
exactly.
no,
what I'm
I
trying to say.
have been there for more than 2 decades.
Right, madam.
Item number 18.
I have for the petition in this matter.
My lord, I am for the respondent, my lord. My lord, in this matter,
For the petitioner in this
my
matter.
lord, I am for the respondent, my lord. In this matter, my lord, Gokul Chandra Chakraborty, Advocate Gokul Chandra Chakraborty is appearing, my lord. He has not come, my lord, due to his wife accident. So, my lord.
My lord, I am challenging the order of the Central Administrative Tribunal, my lord, which is at page, my lord, 92.
My lord, one thing I want to add, my lord. So, for information which I get from my senior, my lord, the respondent has died, my lord.
Okay, respondent died.
Yes.
Okay.
Yeah, Arun Varam.
My lord, I have been told that the respondent
Yes, no, my lord.
applicant before the cat, my lord.
Yes, passed away.
Arun
The
Varam.
respondent, he has passed away, my lord, just now. Then, my lord, I have to get the substitution. Let them.
Can we record your submission?
Yes, you can. Yes, my lord, record me.
Then who are you appearing?
Chandru Chakraborty is appearing for the respondent.
How can he if there is no response?
Yes, my lord, that's the whole thing.
Gokul sir.
No, petitioner.
There is any wakalatnama obtained by the respondent before he passed away, or you don't know anything?
My lord, I am the
When he will be here?
My lord, I am the junior of Gokul Chandra Chakraborty.
When he will be here?
Next week, my.
As stated by the learned counsel for the petition. Now it is your duty to take steps. He is still in service.
No, pension, my lord.
So therefore you will know, the employer will know, if such an unfortunate development has taken place, then you will immediately know.
My lord, that person, my lord, the respondent concerned, my lord, has already retired in the year 2005.
That doesn't mean anything. You must be paying him pension.
Yes, my lord, but now
So
I have
therefore
to
you
take-
will know,
but I-
immediately you will know.
But I have to take instruction from my client. No, I do not know, my lord, now. My lord, 19 is same, my lord. Another 18
my
and
lord,
19.
19. No,
do not
no,
know.
no, no.
Same, my lord, identical matter. I am saying identical matter, my lord.
No, my lord, petitioner is alive, my lord.
Yes.
Respondent is alive. my lord.
Yes.
Yes, my lord, here alive. So, my lord, here I am also challenging, my lord, the order of the learned cat, my lord. 19. Poeta actor হয়ে গেছে তো।
Yes, yes.
Alive আছে। পরেরটা ডাকুন দাদা।
Yes, what's the issue?
My lord, the issue is not that my lord, fixed medical allowance, my lord, was paid to the petitioners, my lord. Now there was, my lord, a clarificatory letter or notice, my lord, was issued in the year 2014 by the Employees Provident Fund Organization, my lord, where it had been said, my lord, that both the spouses were working in the same organization and not getting the CH, my lord, Central Government Health Scheme benefits, my lord. They will get only one. Previously, they were getting, my lord, both of them were getting. But now, my lord, from 2014, my lord, there was a notice, my lord, the employee headquarters, my lord, of the Employees Provident Fund Organization that they will not get. My lord, if your lordship can take, my lord, page 63. This is the notice, my lord, which they have challenged, my lord, before the CAT. Page 63, my lord, this is the letter, my lord, 12/3/2014. By getting this, my lord, they have challenged. Yes. This is a general, my lord, circular, your lordship can say, my lord, of 14. Lordship got it, my lord? My lord, to all the additional central provident fund commissioners, Jones, director, not all regional provident fund in charge of the region, including RPFC, all officers in charge, SRO, sub-regional office, my lord. Running page 63, my lord. Edakunta. Sorry. Kali, sorry. Lord, it is 63, my lord. Page 63, my lord. Page 60. Lordship got it, my lord? Page 63, my lord. This is the letter.
You have not paginated the second brief.
63, my lord. My lord,
In his lordship's brief, it is page 34.
34 is the, my lord, this, my lord, internal, but it running page would be 63.
There is no external paging here.
I'm sorry, my lord. My lord.
It is external, it is outside the brief.
My lord, I'm sorry, my lord, it has not been, my lord. Page 63, my lord. 34, my lord, is the.
Anyway, we have got it 12th March 2004.
Yes, 12 March 2014.
14.
Yes,
Just let us read.
Yes.
So this has been set aside by the tribunal.
This has been, my lord, not to give any effect to. It has been said like this, my lord, not to give any effect to, no deduction in view of the decision passed by the Ernakulam.
Where is the question of deduction? It says that not to pay 2,000 per month, which was being paid, that will not be paid.
Not be paid, but this will continue as what it was in the year 2005 or 2006, my lord. That was the, my lord, if your lordship can take the order, my lord, order is at page 92. 92, my lord. If your lordship can take, my lord, here the penalty made paragraph would be, my
All
lord.
right, we'll come back. Just
অর্ডারসে কত নম্বর আইটেম আমাদের অর্ডার ও
My lord, I'm
Item number 2.
SAT 30.
Leave of justice moved. With the leave of justice moved.
Item number 3.
We noted the submissions without going into the merits. And since the matter is pending before the tribunal, we are not inclined to exercise jurisdiction. Writ petition is dismissed.
Chief, item number 4, Mr. Tapan Kumar Mukherjee is appearing in the for the state. He is out of station, Lordship. Kindly,
Day is 7th.
Lordship, 4 and 6, not today.
Yes, he has informed us 7th and 8th, he is not here.
Oh,
In many cases, we have fixed other than 8th. Probably at the time this was fixed, he was not knowing.
this is
that
today
he-
for judgment or for order?
No,
Further clarification.
yes, it is not for judgment.
Okay. Then another date we fix.
It is not for judgment. Only those two matters were for judgment which we have passed.
Oh, yes.
This was to be considered. Mr. Tapan Kumar.
Obligement. Good.
Under the same heading. Under the same heading, same time.
Obliged.
Grateful, Lordship.
But this was not for.
Item number 18.
My lord, I'm for the respondent, my lord. In this matter, my lord, learned advocate Gokul Chandra Chakraborty is appearing, my lord. He could not come today, my lord, due to his wife accident, my lord.
This is the 5th time you are mentioning this. You think we don't remember?
No, yes, my
Yes,
lord.
let us see. We have said.
Unless this is
We
19,
have
my
said
lord.
you have
Sir,
mentioned.
kindly make it
You have
not today, my lord.
mentioned. Don't worry, please.
My lord.
Yes.
My lord.
Yes.
Yes, my lord. Your lordship was looking to that, my lord.
Page 60.
Page 63, my lord. My lord, I have paginated, my lord. Second copy, my lord.
Oh.
That's
Good. Very good.
yes. Page 63, my lord.
We appreciate your diligence. Yes.
My lord. I'm sorry for that, my lord, but
No, that's all right.
but my lord, before that, if your lordship kindly takes my lord.
So how, why the tribunal has interfered in this?
My lord, the tribunal has followed a decision of the Ernakulam bench, my lord. That's my lord, the High Court of Kerala.
No, what ground?
Ground, my lord, that they have retired. They have already they are retired. They are superannuated, my lord, and now it is at this stage you cannot deduct. That was the my lord. If your lordship kindly takes the my lord, the order, impugned order, my lord, which is my lord, the page 92.
No, what you, the substance of this order which you have passed, if there are two, if there is a husband and wife, then
One
there
of the spouses will
only one spouse will get medical allowance.
Yes, my lordship, I'm saying it was my lord in the year 1997. It was 100. Thereafter, my lord, it enhanced to 1200. Now the my lord Ministry of Labor has decided, my lord, that it may be enhanced to 2000, but one of the spouse will get, my lord, this fixed medical allowances, my lord. One of the spouse will be
No. 2000 was fixed much prior to 2014.
Yes.
2000 was fixed prior to 2014 and both spouses were getting the benefit.
Yes, at that point of
In 2014, you say only one spouse will get benefit, then why pay salary to both spouses?
But in the same organization, my lord.
Correct. So if both are working in the same organization, why should you pay salary to both?
Salary, they were, my lord, it was an additional benefit, my lord.
What benefit? It's a medical allowance per month.
Yes, but lordship can appreciate, my lord.
What is the rationale? What is the rationale?
The quantum, my lord, quantum was, my lord.
We are not on quantum. Quantum is something, if it was a composite order, that instead of 100, we are making it 2000, but this will be common. That would have been a different thing. You had a conscious decision, 2000 per head, and then you say now it will be paid only to one spouse. Then therefore we are asking you, then why not one salary if both are employed in the same organization?
My lord,
what is the rationale, please? How you can sustain such a decision?
My lord, then your, my lord.
We can understand something maybe like house rent. You can say both are in the same organization at the same station, we will give one house rent. That may have some rationale. We don't know what will happen, but prima facie it may be sustained.
It is 63, my lord.
We are looking at 63. You say now it will be one spouse if both are in the same station, in the same organization. What is the rationale? You presume that both will have to tide over things within 2000 rupees. And if they are not spouses, then both of them will get in separate. How it can? Your classification prima facie to us does not appear to be sustainable. In one set of circumstances, every individual will get 2000, and just because they are married, every individual will not get. Is this a valid classification?
Both of them are working in the same organization.
It's a question of medical requirement. The medical requirement of an employee you have assessed to be reimbursable to the extent of 2000. Then how you can curtail an employee just because he is also married to an employee?
But before that, my lord, the one undertaking was required to be given, my lord, and that was given, my lord, that that undertaking was taken. And thereafter, my lord, after arrival of that clarificatory letter, my lord, in 2014, my lord, now in the year 2022, we have informed their banker, my lord, State Bank of India, their banker, my lord, that to deduct, not to give the same amount, my lord, then, my lord, they have moved, my lord, the cat bench, my lord. Calcutta.
What they have given undertaking that will only one of us will claim.
No, that they will. Lord, we have said so, Lord. We have asked them that you kindly clarify whether you are only employing in the organization, whether you are alone or your wife is also. Then they have said no, my wife. Then
so what will they say? If they have a wife, they will say no.
Then my lord, now this is a general circular, my lord. This is a general circular, my lord, issued by my lord by the Ministry of Labor, and it has been followed by my lord, or the letter has been made.
Therefore, they have challenged. You have issued it. Therefore, they have challenged. You have issued is does not conclusively confer validity upon it from the rational point of view. What is the object sought to be achieved, and how do you classify two individuals the medical requirement of an employee, it will diminish because he is married to another employee. Can this be a valid classification? And this is the maximum. And this is for those who don't have the facility of CGHS.
Yes, my lord. Those who are not getting, my lord, the benefits under the central government health scheme, my lord,
Then
that's the problem.
2,000 rupees per month. Nowadays, the way medicine are priced and things, healthcare. So they have followed which decision? It has.
Vernacular bench decision, my lord. My lord, that is, my lord, if your lordship kindly takes, my lord, that's there. My lord, CAT bench, my lord, the Central Administrative Tribunal, Ernakulam, that's, my lord, that order is there, my lord. It has been annexed, my lord, at page 66, internal page 37, my lord.
66.
It's page 64. Lordship got it, my lord? Page 66. This is a CAT bench order. And thereafter, my lord, the High Court order, my lord, is at page, my lord, 73. '67. Should I read, my lord?
So this decision of the High Court was accepted by you.
Yes, Lord, that order, tribunal's order, my lord, where it was allowed, that has not been interfered with, my lord, by the High Court of Kerala.
And the High Court judgment you have complied. But in here you don't want to comply.
No, we are bound by the, my lord, that circular, my lord, that's circular 14 circular.
You are not bound by the declaration of law by the High Court. You are bound by the circular.
Lord, I'm not saying, my lord, but my lord, that circular we have to carry out, my lord, that circular. My
How
lord,
can you, once the court has
14
held that it is not sustainable, how can you do that? This is order of 2018, not challenged by you.
Yeah, my lord, that 18 order, my lord, I do not know, my lord, because it's a Kerala's judgment. What happened?
That's why we are asking you, have implemented without any challenge, or you have challenged it?
I have that, my lord, so for that aspect is concerned, my lord, I have to take instruction.
Without asking this, you have filed the writ petition. This is the first thing which should arise in your mind, that if you have already complied, then why are you not complying here? You find out.
But now, my lord, my lord, the learned cat bench, my lord, has relied upon that judgment, my lord, and passed the order. On the basis of that, my lord, if your lordship kindly takes, my lord, the impugned order.
But we don't know whether this is final between the parties
Yes,
or
it has been finalized, or it has been attained its finality or not, my lord. That has to be looked into, my lord.
Therefore, first find out.
Yes, Lord, I will, my lord.
The issue arising for consideration is whether Yes.
Item number 4, 5, and 6. Your lordship has been pleased to take up in the next week. Now, my lord, in the next week, my lord, I have some difficulties because only 2 days.
He did not say anything.
That's fault, man.
I'm not
16th and 17th only. Because Monday and Tuesday
See,
are
there is a problem. If we don't take up on 16th, 17th, we will not be available from 21st to 2nd May.
logically.
So then it will have to come in May. But ask your friend, where is your friend?
Mr. Mukherjee is not available for the entire week.
Somebody was mentioning, so must be here. You ask him to come with the state council.
Or your lordships adjourn it till 4th, and let us come back and say, lordships.
The order which has been passed in absence of the state council, we will not change. Either you ask him to come before we rise, jointly it can be done.
Or before your lordships.
I need not tell you how to do it.
But that's he thought that Monday is a holiday.
No. We said
Next week
16th.
takes us Monday.
We said 16th. We said 16th because Monday is holiday. It was pointed
Monday,
out.
Tuesday, both holiday.
But in absence of the other side, will not change the order. Will not.
All right, I'm giving the notice.
Either you come before rising, both of you come, then we'll see.
Or your lordships giving notice, come tomorrow morning and say that.
No, or on 16th, we'll see what is it. Don't worry.
Let's see, my lord, if I
If
can.
it can be done today only. Otherwise, yes. Those three orders, ask them.
Item number 20.
$20 million I am for the petitioner. I have served a copy million upon the respondent, but the document return million with endorsement this then respondent number 1, a petition number respondent number 1 to respondent number 1 million. This is endorsement. Yes. Affidavit I have to find this. Substitution million administrative order is necessary because million the substitution for this is person million we have no knowledge million because we are for the Union of India.
Suited.
Yes, certainly. But particulars of the petition document.
Why somebody must be getting his family pension? And there are two applicants.
Yes. Number 1 million in respect of 1.
So both of them are employees.
Only 1 million petitioner. Both are petitioners.
Both applicants are individual employees. They are not related. So only one has.
Yes.
What is the benefit?
Particulars is requirement for my learned friend who appears for the respondent.
What?
The employee.
How he can appear when the person is not there?
That's why Milord, I am saying leave to file a affidavit of service, then Milord, your lordship can take this.
No, but if you know that he is deceased, you have to take steps for substitution.
This back, Milord, I have got the report.
So therefore, now you have to take steps for substitution.
Substitution, Milord. Yes.
What is the other? There is no way out. You have to substitute. What is the issue about?
The fixation of pay.
So therefore, it has some pecuniary implication. The legal error has to be brought on record. Of petitioner number 1, applicant number 1, applicant number 2 served. So for that, you file the affidavit of service. And for applicant number one, you take appropriate steps. We are informed that
Item number 21. Item number 21. Item number 22.
Respondent.
Item number 22.
I think then.
This matter number 22, my lord, I am instructed to appear on behalf of the respondent.
Same on. In presence of respondents, matter is adjourned for 1B. 1B. 6:30.
Item number 23.
এদিকে চলে আসুন।
23, I appear for the petitioner, my lord. The affidavit of service may be kept on record.
Yes.
Lord, this writ petition has been filed assailing the order of the Central Administrative Tribunal. My lord, over here the Central Administrative Tribunal has ruled that since the matter of seeking sanction of the President with respect to withholding of my retiral benefits are under consideration, the original application is premature. If my lord comes to the order passed by the Central Administrative Tribunal, my lord shall find that the tribunal has ruled this application to be premature in nature. However, in the original application, my lord, the entire disciplinary proceeding was under challenge. It was not only that I was aggrieved by the withholding of the pension. Withholding of pension was done or it was contemplated because I was held guilty in the disciplinary proceeding.
So final order had been passed in the departmental proceeding.
Yes. Yes, my lord. Kindly comes to page 123. That is the...
Where is the order of 25/5/2022? You retired on 30th April 2020.
Yes.
And where is the order of the appellate authority dated 25/5/22?
The appellate authority's order is at page 120. 8, my lord. 25th May 2022.
So how you are saying it is final?
My lord, kindly comes to the order of the disciplinary authority, page 123.
That disciplinary authority's order will exist after the appellate authority has passed an order.
My lord, but if my lord peruses the appellate authority's order as well, it is completely unreasoned. It has not taken into consideration.
It is in your favor, sir.
It is, but my lord, it is again telling me to go back to the disciplinary
But
authority.
we asked you whether it has attained finality, so it has not attained finality. Good, bad it may be, but it has not attained finality. That is the first question we asked you. So the proceeding never attained finality.
Yes.
It traveled up to the appellate authority. Appellate authority found that procedure was not followed, therefore remitted it to the disciplinary authority. Now no fresh decision has been taken by the disciplinary.
Not yet, ma'am.
Then how it has been referred to for a decision as regards withholding? By which communication?
My lord, it is recorded in the tribunal's order as well.
No, the tribunal says it has only been referred for a decision regarding withholding in terms of Rule 9.
Yes.
Where is that reference?
That reference is recorded in the order. It is from the submission of the council that we come to know.
There is no order to this effect.
No, my lord. Subject to correction, no.
What do you mean subject
No,
to correction?
I haven't come across that order, ma'am.
The entire brief is there and
it is not there.
You have to say yes or no. What do you mean or subject to correction? You are here to assist. You are here to tell us.
There is a communication whereby the sanction of provisional pension has been issued to me saying that since disciplinary proceedings are pending under Rule 10 of the Railway
That is all right. That they are obliged to do. That they have done. There is nothing wrong
Apart
with
from
that.
the fact the fact that it is awaiting sanction of the president, that has not been communicated.
Where is the proposal? You are appearing. Where is the proposal for recovery? What is the date of the proposal for recovery?
Can you give some time? I need some instruction from the department.
What instruction we are asking you to tell us from the record?
Record I don't have any record from here. So can you,
Nothing to take instruction. The tribunal's order, a prima facie, it appears to be. How can the rule under Rule 9, a decision is possible for recovering a loss when there is a finding in a proceeding or in a criminal case? Till now, there is no finding. How can a recovery be made under 9?
It will send to the.
You may send it wherever you want. It cannot be done. See, Rule 9 has been quoted. For that, no instruction is required. Railway Service Pension Rules, Rule 9, we have seen many occasions. It says only if there is a finding in a proceeding or in a criminal trial. Then for recovering the loss, it can be. Just because you think there is a loss occasioned by him, therefore you will recover, or there has to be a finding. Your appellate authority has remitted the matter for reconsideration. Where is the question? But then even in spite of that, it is premature. Unless the proceeding attains finality, what are you prejudiced by? Why? What is the order you want us to set aside today?
My prejudice is that in a proceeding where the inquiry report itself was not furnished to me.
We are asking you, when your plea has been accepted by the appellate authority, what should we set aside today? The appellate authority's order. Prior to that, none of the orders exist now. Appellate authority has said that it has to be reconsidered.
Yes.
So what is there to question?
I am aggrieved by the learned Central Administrative Tribunal's order. I had
It
challenged
says
the
premature. That is what we are asking you. How is it not premature? If the appellate authority has asked the disciplinary authority to reconsider, it is pending reconsideration, then where is how it is not premature?
My lord, subject to correction, if the disciplinary proceeding itself is fraught with anomalies.
We are not an appellate forum, sir. Please try to understand the limitations of the jurisdiction where you are arguing. That issue has been examined by the forum which is meant for examining this issue. It has found there to be a lapse. It has said to the disciplinary authority to reconsider in accordance with law. So there is no reconsideration. There is no order adverse to you today.
My lord, even
there is no order referring it to the president also because it is nowhere to be found. What is to be done?
Be that as it may, my lord, my retiral benefits are being held hostage.
No, they have directed for release of the provisional pension. That is in accordance with the rule. You will get. That is not an order under challenge by you.
My gratuity,
None of that. You have not claimed any relief for that. You are only challenging the proceeding. Why you are challenging the proceeding when you have got the relief from the appellate authority? Unique writ petition you have filed, or way you have filed. There is nothing. It is a premature. We don't know whether it is which way it will be decided. Maybe upon remand, the disciplinary authority will decide in your favor. Maybe he may not. And how it is continuing beyond his retirement, under which provision?
Give me some time. I don't have that proper rules and all this with me.
There must be a provision for continuing the proceedings.
Certainly,
for the purposes of continuing. You are getting subsistence allowance and all that.
I'm getting provisional pension when I'm retired.
No, but when they are conducting proceedings, provisional pension.
Yes.
There is
The charge sheet was issued a month before my retirement, my lord.
That is not relevant today at all. None of that is relevant. You have got an order favorable to you by the appellate authority. That's why we said, where is the appellate authority's order? You still challenge. We don't know what is the relief you are seeking before the judge. Set aside the charge sheet. After proceeding in the participating in the proceeding up to appellate authority, you have filed a way for setting aside the charge sheet. And what happened in the proceeding after this order passed by the tribunal? This is of 29/7/24. This is this is a long time back. What happened in the meantime?
I know, to the best of my instructions, it has not proceeded any further. It is at a stagnated position. I'm only receiving provisional pension. That is it.
Perhaps you may not be having up-to-date instructions. It's difficult to believe that for 1.5 years after remand, they would be doing nothing. The charge memo is of 2020.
Yes.
And within 2 years, they have done everything. And you say for the past 1.5 years, they have not done anything. Can't be. Find out what has happened. Inform the court.
My lord.
A month before, the petitioner
Number 24.
In this matter, I am appearing on behalf of the petitioner.
My lord, in this,
And the affidavit of service is here.
my lord,
And
I am
may
for
appear.
I am appearing for the respondent applicants, my lord. My lord, I would be seeking, my lord, 1 week adjournment because, my lord, all of a sudden this matter came up. My lord, I am not ready with this matter. Okay. So, lordship. And I'm slightly handicapped also because my brief is not available today also. Two respondent applicants. Respondent applicants, two respondents.
Both,
my lord.
yes, what is the issue?
But we have served.
They are appearing already.
My lord,
They have been appearing.
actually,
And,
my lord,
they
can
are
it be
seeking
1 week time?
No, that,
Lordship grants time and one thing and neither I shall start.
Next week, if your lordship kindly take up.
They have prayed for pay parity, my lord. In entry level, they have been asking for grade pay 4,800. This is the issue.
tribunal has allowed.
Tribunal has allowed. But this is second phase of application which has moved before tribunal. Previously, one application was moved. Their tribunal directed the railway authority, my lord, to pass a speaking order. Speaking order was passed. Challenging the speaking order, this is the second application. And challenging the order of the same, my lord, we have preferred this writ application.
As paid by learned counsel for the respondents.
Great.
1 week, huh?
2 weeks, my lord.
2 weeks.
My
All right. 2 weeks is all right.
Yes, my lord. In the meantime, there are holidays. Many holidays, Good Friday and others, my lord. Poila Boishak and others.
Item number 25.
Actually, all these matters will now. After second. We should list it after the second. Some date after the second.
Pardon, my lord?
After the 2nd of May, give a date.
Second.
After 2nd May, which date? Which date?
Pardon, my lord?
After 2nd of May, give us a date.
Second of May.
Fifth May, Monday.
5th May.
All right.
Number 25.
I appear for the respondent number 1 and 2, Metro Railway.
Mallet. I am for the applicant, Mallet. For the learned tribunal. At the very outset, Mallet, I want to take candid confession that the merit of the case, Mallet, to which the entire fulcrum is based, that was not properly appreciated before the learned tribunal below, Mallet. The pleading, necessary pleading to that effect was not given. However, the circular was there, but even the prayer was not properly drafted, Mallet. So there is an inherent fallacy, Mallet, that I cannot improvise at this stage, Mallet.
So they are seeking grant of some scale.
No, Mallet. The issue is this, Mallet. There was the two things were there. I was working in an Eastern Railway. Then after Mallet, I selected in the Metro Railway. While going to the Metro Railway, because I was departmental candidate and I was working within the railway organization, so therefore I sought for the retention of the quarter. Due to exigency, because my wife is in an advanced stage of pregnancy. That was not considered at that point of time. And ultimately, Mallet, 4 months it took to take the decision. And this at that point of juncture, Mallet, she was already in a 8th month or 7th month of the pregnancy. So therefore, Mallet, when they take a decision, I failed to join with the new recruits, Mallet, on the date which they have already joined. I joined after July. So once, Mallet, after getting the joining, Mallet, in a Metro Railway, I lost two things.
July which year?
July, Mallet, 1997.
And the others joined on?
Prior to July, Mallet. So due to this particular thing, my lord, I lost one increment as well as, my lord, the seniority. And this is the cascading effect of my pension because the compatriots who are getting the salary at least 4,000 above to me, my lord. The main harping issue this, my lord, in a railway, my lord, there is a provision for the retention of the quarter to the departmental candidate or those who are serving within the organization, my lord. Though the circular was annexed, my lord, but necessary pleading to that effect and the enforcement of that particular prayer was not mentioned in the prayer of the original application, my lord.
That's not relevant. The fact remains whether you retained a quarter, you didn't remain a quarter.
Yes, my lord. I
You
retained.
have joined after the others.
Yes.
So therefore, if there is a provision that your seniority and everything will relate from the date of panel, then you may be in a position to claim.
Yes.
If there is not, then if your date is the fulcrum on which the everything is to be determined,
yes, my lord.
then for your delay, what can be done?
My lord, if I could have allowed the retention of the quarter as per the RB circular, my lord, then I could have joined back.
We are not required to go into the legitimacy of that exercise. The admitted position is that you joined after July 97.
Yes, that is fact.
So it has to be seen whether your date of joining will be the date for determination of your seniority, increment, everything, because increment is fixed. Every year it accrues on a particular date.
Yes, my lord. In a July.
If you,
in a
July, yes. So if you have joined after July, after the date of annual increment,
yes, my lord.
then how can you get it?
My
It
lord,
is increment is always on salary.
Yes, my lord.
Unless you get the salary, that increment you cannot get.
Yes, my lord. That is there. But
And seniority also will be determined from the date you join. Unless there is a rule, we don't know. There are many rules which say it will all depend on the panel. For some exigency, if they have joined on different date, that is immaterial. Unless that is the case, is there such a provision?
Well,
Quarter is wholly irrelevant.
My only issue this, pallet, the retention of the quarter was the sine qua non for the respondent that they did not release me. And due to that particular thing, I failed to join before the metro rail.
What do you mean did not release you?
Because the retention of the quarter, the condition was that you have to release the quarter prior to giving you the NOC.
Yes.
So literally, Malet, the benefit of that particular circular, if could have been afforded to me, then I could have joined prior to at par with my competitors, Malet.
And why did you wait for 13 long years to raise this issue?
Malet, there was a interdepartmental things was going on. There is a representations, Katina of representation has been forwarded, Malet.
That is sufficient.
No, that is not sufficient. As per the law, that is not sufficient. But Malet, since the tribunal has gone into the merit of that consideration, Malet, so a lordship
today everything is open to us.
Yes, that is there. That is there.
97.
By virtue of the report, your lordship, all points are kept. Yes.
See your conduct. You say that they kept it pending for 4 months, which was decided after 4 months. So what is that date after 4 months on which it was decided? What is that date after 4 months? It must be before July.
Yes, but that is.
So therefore we are saying that fact is irrelevant. After they have decided, you have again taken more time. That's not a question of those 4 months. If that is excluded, you will get. You will not get.
When they have taken the decision of the 4-month pilot, at that point of time, there was such a medical exigency, Malet, so I compelled to give my second representation for the retainers of the quarter.
After a decision, is there any provision authorizing filing of such a representation?
Yes, Malet. So far as provision, Malet. So far the provision is concerned, Malet, that is RB. There is a RB rule.
RB says you have a right to make an application for retention. You have a right to consideration.
Yes, and that
once it is considered and rejected, then you can again make a representation.
The first representation, Malet, which I have given was taken a decision on that representation after 4 months. When this particular order came to my knowledge, at that point of time, their medical condition was so precarious. So I chose to continue with that matter. And ultimately, I requested the authority to kindly release me after such and such and retention of quarter.
How long did you retain it in excess?
Ballot that I left the quarter ballot 11/8/1997, while the first ballot 5/12/1992, I got the offer to join the Metro Railway as a trainee motorman.
Yes.
So from 5/12/1997.
5/12/1992.
No, 1997, my lord.
Just now you said 92.
Sorry.
So how can it be 5/12? You said you have already left in
5/12/1997.
August 97. You have left. So how can you get an offer in December 97?
5/12. Just a minute, my lord. I need to check, my lord.
You said 11/8/97. It has been.
Sorry. That is the 5/12. I'm giving the letter, my lord. Appointment letter. 5/12/1996 is the offer of appointment.
That can be, yes. So for 8 months you have retained.
Yes, that is there. And your lordship will go into the pertinent circular, my lord, which I failed to appreciate during the course of decision, my lord. Kindly come to page 99, which para 8.6.
No, first. So 5/12/96 was the order.
Yes, my lord.
Asking you to join by.
This is my appointment letter, my lord. That is at page 56.
56.
Yes. Temporary appointment of trainee motorman. Then after.
What is the date? They want you to join by which date?
This, my lord, is not written that by which date you need to put joining, my lord. But then after, my lord, the second letter, my lord, that is page 59. That is the letter dated 3/1/1997 issued by the Metro Railway. The second para, he may be therefore pleased to be released to the railway for appointment as a motorman. Then after, my lord, I given my.
No. Come to page 57. There is a date. 3/12/96. 23/12/96. If you intend to take up the appointment on these conditions, please signify your acceptance and return the form. In the event your acceptance, call at this office before 23/12/96 for arranging medical examination, execution of bond, etc. So did you take this step?
I beg your pardon, lordship, which paragraph?
Paragraph 11.
11. If you intend to take the appointment to those, please specify your acceptance and return from the duplicate copy of the which is enclosed for retention of you. In the event of acceptance, please follow the office retention in any medical examination. Only debts will not be removed by that.
23/12/96.
23/12/96. Okay. Malit, this particular condition is for the freshers candidate, Malit. But my candidature was since I was working in the Eastern
You
Rail.
are not required to give this.
No, Malit. So the medical examination itself is not.
So you are asking us to see page 59.
59.
Just read the first line.
A copy of the appointment of the motorman in scale of such and such. A copy of the application dated
23/12/96. So you have submitted.
23/12/1996 submitted by the Subhash Chaudhary.
So you have submitted. It's not that you are not required to submit.
No, so for that condition, my lord, that condition.
There was a date.
Yes,
we
there
asked
was
you whether there was a date. There was a date,
There
and
was a
by
date.
that date
Yes.
you have submitted.
Yes, there
already.
was a date.
Thereafter, you appeared before the interview board.
Yes, my lord. Please to release, and then after, my lord, the second page 60, your lordship kindly come.
Therefore, please.
Where I prayed for first time the retention of the quarter.
Yes.
Page 60, your lordship.
How do we read page 59? Just see how you have given it. How can one read this? You read the second paragraph, third paragraph. How can we read it?
I'll produce the type copy.
What is this? Why do you file like this?
No, my lord, most of the copy, like 61, I have.
You are obliged to file a legible typed copy. Why should you not file?
I will file.
Further to the above,
some
you
of the
are
copy which I
also
have
requested to forwarded the No, fitness is also required. Needed fit certificate.
Yes, man. These
in
things
category A.
complied. There's
How
a
you
no-
are saying it was not required?
There was no
Everything-
aspersion from the department, my lord.
But it was required. You
Yes,
said
I have
not
already complied,
required.
my
That is not a, that's not correct. It was required.
I have complied, my lord. Then after, my lord, the 17th January, that first I given my representation with regard to retention of my quarter. Here from the cause of action start with regard to the retention, my lord.
You did not inform the metro that look, for this reason I am stuck. You only wrote to your railway that
Yes, my
allow
lord,
me to
where I
continue.
was working, my lord. Yes.
You did
Because the
not
copy has not been marked to the metro.
No, there is any application made to the metro that look, for this reason I am stuck and I am.
No, my lord. There's a copy is not available to me. Copy is not available. Why are
How can they?
copy to them? The condition. Okay. Yes.
Not going for about 8 months.
Yes. Yes.
December. December. Oh, sorry.
The page 61 and 62, my lord, is amply clear that despite said particular request for the retention, the Eastern Railway was adamant to release the quarter. That is apparent for the record itself, my lord.
You have no enforceable right. You had no enforceable right. But at least your bona fide required, you should have informed your employer that look, I am stuck up for this reason. Please give me some time. You not inform them.
Because, my
You
lord,
were more involved in only retaining the quarter for whatever reason it was. We don't know.
because, my lord, I was having the legitimate expectation to that effect, my lord, since this particular benefit
There
has
can be a
been,
legitimate expectation only if you have a right.
you have right, my lord.
Where is the right that they
my lord,
must allow retention in every circumstance?
yes, my lord, but this particular retention clause has been given to one of the colleague which was working in Eastern Railway.
May
So
have been.
therefore, my lord,
That
on
was
the
not an issue.
so there was
Not the concern of your new employer. He has nothing to do with this. You have not even intimated him. Just see how you have approached.
Therefore, my prayer with regard to the Eastern Railway too, where I was working. So at least they could have given opportunity or sorry, not opportunity, they could have given the concession on that point of the retention of the quarter. The new employer was having no impediment to that regard, my lord. It is only due to that particular I have not been able to release due to retention of the quarter. So therefore, the new employer.
Your new employer concerned with that. That was something you were contesting with your old employer. He is only concerned with the date of joining. He has nothing to do with release of your quarter. He has nothing to do with your consideration for retention.
So therefore, my lord, my prayer
Therefore,
with
he cannot be made to, and the employers who have joined their employees, why should they suffer on your because of your delay? And in their absence, how it can be done? How can you be given seniority over others? You cannot be. There is no ground.
So far, the seniority and other parts are concerned, I have given a concession to that. Sorry, I have given a go by because I have specifically pleaded.
Okay.
This
So now what is your
only contention is this, mallet? My increment, which was given from the
what
July.
is the date of increment due? 31st July.
31st July. Mallet. So when they calculated mallet, there is a difference. They are getting one more increment. I am getting less one increment. So that is the variation of the 4,000 mallet with the same batch. And this particular aspect, my lord, on a numerous occasion, I have taken that plea before my erstwhile employer to consider on that part. So I'm not saying that when the Metro Railway is having having any fault because they are abided by the rules as such. If your lordship kindly consider the pay slip which I have annexed, my lord, that is at page 137. The salary is quite depicted in this particular salary slip, my lord. That
So you must have been drawing salary from the railway.
Yes.
You must have got your increment in July at the railways.
No, my lord. In a Metro Railway, I was not getting.
No, but before the Eastern Railway, you must your increment must have accrued for July. If you have continued to 31st July
of that particular
you
year,
must have got the increment for that
particular year.
Yes.
Okay. Because this particular matter decided after the 6th CPC, therefore this particular matter came into knowledge of this applicant. Because the 6th CPC ballot, there was a date of increment fixed. That is last of the June. Whosoever is working, that is settled by the Supreme Court even.
So wherever you are not getting anything from railway, Eastern Railway.
Eastern Railway.
How long did you serve with the Eastern Railway?
I served from 80, 90, 88 to 11/8/1997.
So what are you getting from the railways now?
I am getting the pension now.
Therefore, we are saying if whenever the CPC has been made applicable,
yes,
it will apply. You must be getting it from there.
No, my lord.
If you have continued beyond that date, 31/7, where have you said that you are not neither getting it here nor getting it from the erstwhile
No, my lord,
employee?
that salary slip is quite apparent from that. That I'm not getting.
Salary slip is not of the erstwhile employee. You were serving under the Eastern Railway. You worked till August.
I was serving in the Eastern
Railway.
Railway.
Till August.
Yes.
The date of accrual of annual increment on that year, you were serving with the railways. And you say you are getting pension. So if it was made applicable with 31st July, it must have been made applicable to you in the Eastern Railway.
In a Metro Railway.
Eastern Railway, you were still there on 31st July.
I leave the Eastern Railway
in August
in 1997.
In August.
In August
Yes.
1997.
So on 31st July, you were very much there.
But here, what is the distinction factor, Valet? The person who have joined at par with me.
So you will get increment from both places. You will get an increment from Eastern Railway and you will get an increment from the Metro also.
Yes, your lordship is right on that part. Yes, I need to take instruction on that.
What instruction? It is clear as daylight. You are there on 31st July.
31st July.
That
I was
is your case.
Yes, that
So
was.
how can you get two increments? How can you get two increments?
I'll satisfy your lordship. Just praying for a short accommodation, my lord. I will take instruction and
tomorrow.
Tomorrow
We'll proceed.
Yes, my lord. Let me place, my lord, the insert.
After he completes, we'll hear you. Not today.
My lord,
In presence of the learned counsel for the respondent.
tomorrow it will be at what?
Item number 26.
Well, in this matter, I am for the petition, but I am told that service has not completed yet.
issue on merits. We'll see service later.
I am praying for some time.
Huh?
I'm praying for some time.
Why, madam?
The service has not completed, my.
Service is not required. Let us see what is the issue. If we think that they are to be served, we'll direct for service. You can proceed. Yes. Yes.
My lord, petitioner has come before their lordship. An interim order has passed by the tribunal. Stay order of discharge order of the petitioner responded.
Stay order. What is the date of the impugned order?
He appointed 30th September.
This is of September 9 to 24.
Yes.
What happened after that?
Matter was pending there, but in the tribunal, but in between them, petitioner has come here to state the order of this discharge.
Where is the discharge order which has been stayed? Where is the discharge order, madam? A1 discharge.
আমি বুঝতে পারছি না লেখাটা বুঝতে পারছি। My lord, page 131.
131.
Not Jonathan.
And where is your reply to the show cause? 8 December 23.
Page 52, my lord. Say opposition. Which was it? Good director. After.
What is the NCO? While attending NCO. What is NCO? He says he has suffered this lowering of medical category while he was attending NCO, attending to NCO. What is NCO? He was a clerk subedar.
Lordship clerk.
What is NCO?
Clerkship course. Clerkship course.
Hmm?
Clerkship course. NOC.
No, NCO. You see his reply, paragraph 4. I am suffering from CVALT, hemiplegia, intracerebral hemorrhage, right temporal region and primary hypertension with low medical category P2P with effect from 24th August 22 while I was attending to NCO's clerk course. What is this NCO's clerk course? At Artillery Center, Hyderabad. Presently, I have almost recovered from illness. What is this NCO? So it was during some course, he says he has acquired this condition. What happened after the interim order? Any date has been fixed?
23rd of April.
23rd April. Pleading has been filed by both sides. You have filed your opposition.
There, yes.
Then let them decide it. Why? Yes, take down.
Item number 27.
Yes, madam. I'm for the petition. Copy. আমি কপি দেবেন তো আমি এবারে সার্ভিস Page number 84, your lordship has directed to page number 84, my lord. Earlier order, my lord, your lordship.
82.
84. Your lordship has passed the order for face application, my lord. It was almost hard, but the prior portion was not clear. For that reason, your lordship directed to file the affairs, my lord. The case of the petitioner is that, my lord, petitioner husband was an ex-trackman, my lord.
Was?
Ex-trackman. He was
Trackman.
retired. He was retired on 2004, my lord.
Retired in 2004.
2004, my lord. Thereafter, he was getting the pension. And at the time of retirement, my lord, he has given the declaration that he has 2 wives and the 3 sons, my lord. At page number 21, my lord. Page number 21. As per the declaration, he was the 2 wives, my lord, Gulen Rajbongsi and Gulabi Rajbongsi, and other 3 sons, my lord. 2 daughters and 1 son. My lord, first wife, my lord.
He was in the
Gulen
railways.
Rajbongsi has died during the lifetime of the employee, my lord.
Who has died?
The first wife. First wife has died, my lord. And thereafter, the only wife, the Gulabi Rajbongsi is the petitioner, my lord. And the railway has taken the plea that during the lifetime of the wife, how can the second marriage has been done? That was the only point, my lord, taken by the railway, my lord.
And the 3 offspring are from the first marriage or second marriage?
The second marriage. Petitioner is the second wife.
The 3 children are from the first marriage or second marriage?
Second marriage. And my lord, it is stated that similar circumstances, same railway, my lord. Same railway page number.
So what happened? What happened? The OA has been dismissed.
OA has been dismissed and review has been filed.
Why review has been filed?
A review was filed, my lord, before the honorable cat, my lord.
Why?
Because the similar circumstances, it was considered by the same railway.
So therefore, you wanted the tribunal to reconsider.
We prefer reconsider.
Can that be done in a review?
For that is review was filed. But it
So
has been
can
also
it be
rejected,
done? Can it be done in a review?
No, actually not. But how it was filed by the another advocate, my lord.
Then OA, the review is rightly rejected.
Apparently there is a mistake on record, there is face of record that should be filed. But however, the RA was filed. And in the similar circumstances.
And what is the date of the order passed by the OA? In the OA?
In the OA, my lord.
Where is the order passed in the OA?
Order dated, my lord, 22/5/2024, my lord.
No, that is the OA order.
OA order. Yes. Only it was rejected only that one plea that the second marriage was done during the lifetime of the first wife, and but there is a দেখো ঠিক আছে দেখো দাঁড়াও কি যা চাইবে সেটা তো বইটা আছে এমনি বলে দিলি ঠিক আছে
Yes.
Yes, my lord. As per Rule 75, my lord, in the pension rule, my lord, there is a provision by the in the railway organization. There is a rule of the Eastern Railway, my lord. They and on the next page that is 65. Next page, my lord. When the two wife is there, my lord. That's it.
After permission of the railway.
Permission of the railway, my lord. Now the first wife is not alive, my lord. There is only wife.
What are you, if you are
When the
referring?
declaration has been accepted, my lord, at page number.
There is no
21, my lord.
declaration. There is no declaration. In the PPO, he has given only one.
Now, one, my lord, page 21, my declaration has been accepted.
What accepted?
Prior to the retirement, he has given the
What do you
declaration.
mean accepted? If he has not married with permission, how he can get? This will apply to those who have married after permission.
Several judgment is also there, my lord.
Show one.
Court has taken the view.
Not several. Show one. Show one judgment. We don't want to see several. Show one judgment.
No, see the coordinates also.
Show one judgment. We are not asking you to
Not
show
only that, my lord, similar circumstances, Eastern Railway in the division of the Katia, same division. At the page number 56, my lord.
56.
56, my lord. The nomenclature was she was also the second wife. He was also the second wife.
You are understanding what we are saying, or you are not understanding what we are saying? There is no bar that second wife cannot get. There is a bar that you cannot solemnize marriage during subsistence of first marriage.
The Hindu law, as per Hindu law.
Unless you do it with permission of the relative.
Yes, yes.
So when it says second wife will get, that means second wife who has married with permission. That is deemed. Otherwise, how she will get?
How the second marriage, the nomenclature of the second marriage has been given in that permission, my lord, 56 page number.
Let us see. What is this 56?
The second wife.
This is not any
Page
order.
number 56, my lord.
Yes.
56, my lord. The payment has been made from the accounts department, my lord.
So what does that mean? That she has married without permission of the railways?
No, that is not the, my lord. That
Why are you showing this? This is an irrelevant thing.
no, nomenclature has been given in the second.
This is irrelevant. This is irrelevant.
The second
The
one
point is, you are relying on Rule 75. You are only relying on Rule 75 and a correction slip.
Now, when there is a two wives, that has been stated there. When the one wife has died, then second wife, you will get the 100% pension. And how the verbatim has been given, that it is expecting that there is a two wife, or that is in the that.
It is expected that there will be two wives, and the second wife has married after permission of the rail. In your case, there is no permission. If there is after permission, then only there is question of second wife. It is clear. The tribunal has taken note of this provision.
Or there is in the.
Cannot be. Sorry.
Or there is in the.
The children are getting. The children are getting.
No eligible.
No.
Children are also not getting. Why children are not getting?
They are all settled, married.
Oh, they don't require.
No, they are not. Only the wife is there, my lord.
What can be done?
And how
can be done?
ওই অর্ডারটা তো নাই এখানে না এই যে ডব্লিউ পেজ এই যে মানে প্যারাগ্রাফ 12 এই অর্ডারটা তো আসেনি তো আপনারা জানেন page number 13. জানি অর্ডারটা কোথায় রাখলো আমি জানি চলে চুপচাপ থাকো দেখি না page number 9, my lord. Page number 9 and paragraph 13. The coordinate bench judgment has also been taken. Paragraph 13, page number 9, my lord.
Page number
9.
Of
the petition, my lord. Of the petition.
DCRT.
Pension. That the petitioner state that the regard to the similar cause of action, respect of the interest of the gratuity and coordinate bench of the honorable passed an order of the Union of India versus wherein the second wife.
Show us the order. Show us the order.
The order might not available today, my lord.
You have not said that. You have not said what we are asking you. There is no bar. But the point is, we don't know whether she had married after permission or not. In that case, where the court has granted.
Is the internal matter.
No, it is not.
It is permission may be taken or may not be taken within the purview of the railway as because the declaration has been given, my lord. And when the declaration has been accepted, whether any action has been taken for the submission of the name of the two wife, that is also be seen, my lord.
Very well. Where is that provision that it has to be after permission? Which provision says after permission?
My lord, I am to seek instruction from the department
11,
and data part
75.7.
What I have been given the brief, it is incomplete one without annexures. I have pointed out my learned friend also. He assured me that he will supply.
You have copy of the railway service conduct rules?
Yes.
Railway service conduct rules.
No, railway service, no, my lord. There is railway
That
service
says
gives the
that-
permission as well.
Where is it? Show us. Don't just tell us. Where is it? Show us. Railway service conduct rules, 1966. You have it?
No, there is not available, my lord. But the rule is there, my lord, only when the without permission has been.
Ask for a copy. Get 2 copies of railway service conduct rules, 1966.
বলে দিলাম তো, বলে দিলাম তো। আরে আপনি চিন্তা করছেন, বলে দিলাম তো এটা। This resume বলে দিলাম তো। হুম।
Also, yes, you give him a complete copy of the brief. Since refer
এটা রুল আছে ঠিক ঠিক আছে
Number 28.
Madam, may I please, Your Lordship, Madam, I am for the petitioner. Madam, I am then challenging the order. Madam, Annexure P2, page 48. Madam, where is that order? It is said that well, operative part of the order, Madam, I am reading page 50. In the facts and circumstances of the case, the ends of justice shall be made if the applicant is allowed to resume his duty as a substitute Bangla. Madam, before you start, my lord, I am seeing that applicant, my lord, is the respondent number. What respondent number? My respondent number. Respondent number 1, but I have tried to solve it, but he is the evidence service is there, and the postal envelope is returned left without left without that I am not reading, but not served. It was not yet served. The service was complete. The evidence of service, can I take it? That respondent number one did not join his transfer post along with his superior, that is KM Pandey. She respondent number performer respondent number one, two, respondent number two, but performer respondent number one. Well, already Mr. Pandey is already retired.
It has been dismissed in default. It has been dismissed in default.
Yes.
Then why are you coming here?
Then RA's file,
RA is dismissed for default.
in the view present disposed of. Disposed RA.
Read paragraph. Read paragraph 3. Please read. Please read. Please read it. Paragraph 3. Read for us.
It has been said that RA is pending before the tribunal since 2011.
11, only 12 years. Yes.
In spite of the case listed for hearing on various days, none remain present. Today
also there is none to be
present for the applicant.
Then
that related state we do not deem it fit to
you are for the respondent.
But I am the Union of India.
You are the applicant in the RA. So if you are not present, what the court will do? What the tribunal will do?
But there is nothing in this matter as because the respondent is not never joining at that post, and the superior, the transferee post, and the superior also retired.
So then why have you challenged? That is what we are trying to understand.
But it is not possible for us.
Everybody has retired, so how he will join? What will he do?
It is not possible for implement the order of
which order?
The tribunal.
Which order? Show us the order.
That order dated 55.
Where is that?
55. তেরো নয় 2010 48 তো আছে হ্যাঁ 48 তো ছিল রিভিউ অ্যাপ্লিকেশনের সঙ্গে একটা আছে অ্যাপ্লিকেন্ট ইজ অ্যালাউড এটা তো এই জায়গাটার কথা তো বলতো অ্যাপ্লিকেন্ট ইজ অ্যালাউড হ্যাঁ
Yes, so this was passed in 2010.
So in the facts and circumstances of the case, ends of the shall be made if the applicant is allowed. My lord,
Yes.
there is no question of allowed. My lord, he never can join with his superior.
So where is this petitioner now? This applicant, where is he now?
My lord, I do not know, my lord. I try to search, my lord, but the envelope is returned with a endorsement. The envelope is linked to Joseph.
It is returned to
My lord,
sender.
if your lordship will please to do that, I have to try to serve again.
No, substitute bungalow peon means it is a permanent post or
no?
Then why are you worried?
Railway authorities audit that whether contempt application will filed before the tribunal or not.
For 12 years, contempt has not been filed. Now contempt will be filed. Yes, take down. There was Affidavit of
Yes, now. Petition is disposed of.
you take that plea of impossibility to comply if a contempt is filed. We have said that.
Number 29.
May please your lordship, in this matter, my lord, I am appearing on behalf of the petitioner. It's an application petitioner came
But I am
before the
appearing on behalf of respondent number 1.
My lord, petitioners came before your lordship, challenging the order of the CAT for their pro-rata pension. এটা একটু জজ সাহেবকে দিয়ে দিন।
yes.
My lord, petitioners work church employees. Thereafter, my lord, their absorbed in a permanent post. in the-
95, 1st January 95.
Right, my lord. Absorbed thereafter, my lord, after retirement, they applied.
When?
In the year
95 they were absorbed. When did they retire?
এখানে তো ইয়ে করে। In the year 1995, yes, petitioner permanently, permanently absorbed. Thereafter, when retired, that date is not here. But, my lord, the tribunal, my lord, wrongly, mechanically decided the matter.
Mechanically?
Yes, my lord. Your lordship, kindly go through the paragraph. Kindly take the trouble to go through paragraph 6 and 7.
What does it say?
It says, if there is a 10 years, you have to complete 10
No,
years.
no, tribunal has not gone on merits. Why are you going in merits?
Then, my lord, in the
Whether you can arise and awake at any point as per your sweet will and walk into the corridor of the tribunal. That is the law. That is the only thing.
then
We are not on mechanical and application of mind. That's not the order. The order is totally on a different premise. More than a decade late. No application for condonation also. No representation whatsoever. The Administrative Tribunals Act is clear. Section 21 is very clear.
No, my lord.
Unless you comply with the requirements, can you invoke the jurisdiction?
Question arises, my lord.
That is the only question. After that, every question will arise.
Yes, my lord.
So let us see how you overcome. Show us. Yes, on that show us. That no representation is required under the provisions of the Tribunals Act. And any day you can go to the tribunal you feel like. Let us see.
Josh, your lordship, kindly come to the paragraph 10. '74 Supreme Court cases 317.
This case, they had come from the erstwhile state of Hyderabad. It is that case where they had come from the erstwhile state of Hyderabad as Mamlatdars. They were to be promoted as deputy collectors. If I am not mistaken, it is perhaps that case.
Right.
And that case, there was a specific provision which was being relied upon. There it was not like you, that for 11 years you are sitting with folded hands and all of a sudden coming to the court without exhausting the statutory, complying with the statutory requirement under the Act, under the Administrative Tribunal. Well, it's not a question of delay and latches per se.
But on the delay ground, they have rejected my application.
Yes, correct. So we'll consider this. Anything else? We'll consider this. We have understood. We have had the occasion of seeing this judgment earlier.
Yes, my lord, in here,
Yes.
Supreme Court is very clear.
Yes, para 10 you have said.
Yes. Your lordship, kindly come to page 327.
Yes.
327.
3 to 7, you said paragraph 10.
Paragraph, yes, my lord. Paragraph, next page. Paragraph, page number 327.
Yes.
Moreover, it is noticed that the claim for enforcement of the fundamental right of equal opportunity
Yes.
under Article 16 is itself fundamental right guaranteed under
Yes.
Article 32.
All
And
right.
this court, which has been assigned the role of the sentinel of the of the protection of the fundamental right, cannot be easily allowed itself to be pursued to refuse
Yes.
relief solely on the the ground of laches, delay, or the like.
Yes, all right.
It is not mechanically allowed. It's similar cases allowed by the Delhi High Court.
All right.
Government of India submitted to the judgment and
Where is that? Show us.
it's here, my lord, with my petition.
Yes, show us that.
Union of India submitted.
Page, where is that judgment?
Just a minute, my lord. Page 67, annexure A6. Before that, my lord, principal bench of the CAT, my lord, also decided that the High Court Delhi in Union India, O.P. Sharma's case, CRL 1088 has ruled that one is eligible for pro-rata pension even if he has ranked service for less than 10 years.
No. This case, they have retired in 2007. They have approached the tribunal immediately. How you are saying this Delhi High Court?
The pension will
This
be
Delhi
about-
High Court, Delhi High Court, they have immediately approached.
No.
Please see the date. They superannuated on 30th April.
The Union of India submitted.
Please see page 68, third paragraph. They retired in 2007. They filed OA in 2008. The writ petition was filed in 2010. This is not a case of 11 years sitting over the issue. You have to cross that hurdle, then the issue of pro rata will come.
My lord, Delhi High Court on this observation allow the application. The tribunal has relied upon the Union of India versus O.P. Sharma 2002 2-1.
Now, where are you reading? From which page?
68, your lordship referred.
Sir, we are trying to escape the main issue that we are asking you to address. You are going on the entitlement. We are on this, on the sustainability of the tribunal's judgment before us. It is not as to whether you are entitled or not. It is whether you can invoke the jurisdiction at your own sweet will after a decade. That is the only issue. So therefore, on that, this Delhi High Court does not help you. They retired in 7, they approached the tribunal in 8, and they writ petition in 2010. They have pursued the issue. So therefore, their cases, this will not apply to you, not at all.
My lord, my lord, this is the right of the petitioner, constitutional right, pension.
Yes.
What is pension, my lord? Deferred payment of salary.
Yes.
It is their duty, my lord, to give the pension.
They don't think you are eligible. Why? How will they give? It's not a case where you have retired after qualifying service and you have not been paid. You are trying to include some service and make out a case for grant of pension. It is not otherwise. It is not on that line of cases that pension is not a bounty. That is not the line of judgments which will apply to this case. This is, if you are diligent to enforce this right, then only the court will look into it. Not if you sleep over it for a decade only, as in your case. In this Mamlatdar judgment, we have seen on various occasions, there the facts were different. There was a clear representation by the new state of Maharashtra that all these Mamlatdars who are coming from the erstwhile state of Hyderabad, this is the way we'll count their seniority. This is how they will be considered for the purposes of promotion as deputy collector. That was all there in the document. And therefore, the court has considered that aspect.
That judgment, my lord.
This judgment that you have relied upon.
Is for the delay of 12 years.
Correct.
Condoned by the
Correct. That is the facts and circumstance.
Right.
Every case you are aware that it applies to a particular set of facts and circumstances. Cannot be applied to each and every case. There was many features there. We have had the occasion of seeing this. Can be done. What is your date of retirement? You have not told us. You were absorbed in 95, but you have not told us when you retired. Your OA is your OA part of the record?
Sorry, Milord.
Is your OA part of the record? Have you filed copy of the OA? In the writ petition, have you enclosed the OA?
Yes, your retirement date কোথায় দিয়েছে? নেই।
They were working on which post?
Milord, different posts, Milord.
Grade 4 employees, Group D employees.
Sorry?
Group D employees.
Yes, Milord. Firstly, they employed as a work charge and employee. Thereafter, they absorbed in a power grid corporation.
In 95, when did they retire? We are trying to find that. From 83, you say they were working in the electricity, regional electricity board. When did they retire? They were absorbed in 95, that you have said.
On 1995, Milord, the petition permitted absorbed the power grid corporation of India.
Really? Date is not. Did you file an opposition before the tribunal? They are grade Group D employees. From paragraph 4.1 and 2, it appears that they were approaching some authorities. And what is the date of their retirement?
It's not written.
So how the tribunal knows that it is delayed unless their absorption is of 95, but when did they retire? Unless they retire, where is the question of pension? So calculating 10 years.
One thing I find, Milord, that they made application in 2016.
Yes, that's what we are saying in paragraph 4.23 that has been noted. From the OA I have seen. In 2016, they have made the application and 1 year thereafter they have filed the OA. So section 21, how it
have purview of this section 21.
Then they have filed the application. How it has been? He is not telling us. He is going directly on the merits. We are asking you repeatedly to tell us what is there on delay. You are not telling us. They have made representation in 16 and within 1 year they have filed the OA. You are not telling us. Now when we are looking at the OA, then only we find out. You are only arguing the law without going to the facts. How can you argue?
Yes, Milord. On 28th November.
You file an opposition then. Mr. Bagh, you file an opposition. Yes. The learned.